Good afternoon, everybody. I just want to point out that while we've been doing these webinars and doing all of our education electronically and over the internet throughout the past year plus, we are now starting to do some small educational seminars in person. So please call our office or check out our website to find out that information. We're excited to be coming back to you in person and live, as well as in your living rooms or kitchens or offices or wherever it is that you're sitting, maybe out in the sun somewhere. So today we are going to talk about the new power of attorney law. This is a big deal in New York. A new law was signed in December and goes into effect after June 13th. So as of Monday, clients in our office will be signing a new power of attorney. So today we're going to review what the power of attorney is, what the changes are in the new law, what you can expect, and what you should know about your own documents and seeking advice regarding whether or not you should be signing new documents based on the new law. So first of all, a power of attorney is a document in which you, as the principal, name an agent to act on your behalf. You're giving them the authority to handle certain affairs. Now, exactly what you're giving them the authority to do will be based on what powers you actually put into the power of attorney document. So there's a grant of authority in the document in which you could list a catch-all, which gives full powers as listed in the document, or you can pick and choose the powers that you want to confer. And depending on the purpose of why you're completing the power of attorney document and your other circumstances, who you're naming, etc., you're going to want to figure out if you should be giving full and complete powers or limited powers. And that is going to depend on your personal circumstance. So that's a great first time to realize that you should be discussing with an attorney what the power of attorney document does, what the options are for the powers that you can be giving out, and what is going to be best in your situation. A power of attorney document does not usually require incapacity. So if I am the principal and I'm naming someone to act as my agent, that person could have the power to act while I still do. It is not that they are only in control or able to handle things once I become incapacitated. Now, you can put specific language into the modifications of the document that says this is only in effect if I become incapacitated, but we don't often require that or suggest that to clients because it can be very gray area as to whether or not somebody's incapacitated. And I may need or want assistance handling things and not be incapacitated. And so we don't like to put that in there unless it makes sense. So the vast majority of our clients have documents that are in effect when they sign them. So the power of attorney, again, will list the powers that I'm actually granting to my agent that I'm naming to act on my behalf. And then it sets out the rules of what they can and can't do within the terms of the document. Now, as a little bit of history, there was a power of attorney law. It's actually under the General Obligations Law of New York State. And before 2009, you may have seen it was, that long form, and it was a front and a back. Long meaning it wasn't 8.5 by 11, it was 8.5 by 14. And it was a front and back of a page, and you would initial the catch-all and sign your name, and then you gave full power of attorney authority to another person. Well, after some litigation and the realization that some people maybe weren't understanding the purpose of the document or were taking advantage of the powers under the document, the legislature made big changes to the document in 2009, adding in specific authorities regarding gifting or transferring assets out of your name, requiring that the agent that you're naming sign the document and accept their responsibility as your fiduciary to act on your behalf. And then small changes were made in 2010 to amend that 2009 form. And since 2010, that's the form that we've been working with. And so if you had a document that was signed in 2009 on the 2009 form, it's still perfectly valid. However, if you signed a document after the enactment of the 2010 law, but you signed it on the 2009 document, you didn't have a valid document. So that's going to be one thing that you're going to want to look at is if you have a document right now that you signed after the 2010 change in law, September of 2010, but it was signed on the 2009 or earlier form, it is not a valid power of attorney. If you fall in that category, you are definitely going to need to sign a new document after this new enactment this weekend, so starting next week, to have a valid power of attorney, because no matter what, nothing is grandfathered into this new law if it wasn't valid when it was signed. That 2010 law had a statutory gifts rider attached to it that specifically allowed for transfer of assets out of a person's name. That's going to be one of the big things that we're going to change in the new law. So again, the new law is effective 180 days after it was signed. It was signed on December 15th of 2020, and therefore, and the governor signed it, and there were amendments made to it since he signed it. And the new law will go into effect June 13th, which is this Sunday. So starting on Monday, again, we'll be signing under the new law. We do grandfather in prior signed documents, again, that were valid when they were signed. So they had to have been properly drafted and also executed properly under the law that was in effect at the time that it was signed. Some of the things that have changed in the new law is, for example, substantial compliance versus exact wording. So it used to be that if you even had one word that differentiated from the statutory form, from the form written out in the statute, you did not have a valid document. So for example, if you were supposed to have the word the in a sentence in the document and the word the was taken out, you technically did not have an exactly worded form. If it was in that caution to the principal, especially that big warning on the first page, you would not have a statutory form and it could technically be rejected as a non-statutory power of attorney. Now, under substantial compliance, basically, if you did something like left out the word the when it was supposed to be there, as long as it didn't change the meaning of the sentence or make it so that the form was ambiguous, you could still have a valid power of attorney document. So it allows for some mistakes or errors in drafting, which is much easier. It also allows us, by having substantial compliance, to omit certain sections that might not apply in your situation. We have eliminated the statutory gifts rider. So it used to be, again, that you signed the power of attorney document, you had it notarized, and then there was a rider attached to it that had to be signed at the same time. That was actually a second document that required a notary and 2 witnesses that allowed for your agent to transfer assets out of your name to a loved one, to a charity, to a trust, to create trusts, to fund trusts. That was all in a separate rider document. Under the new law, that is not a separate document, and I'll get into that in a few minutes. Another change is the increase in family maintenance limit for gifting if you don't have those special provisions that allow for unlimited gifting. It used to be that for family maintenance, you can give up to $500 annually without any specific further authority. They have raised that amount to $5,000. So if there is no other gifting authority, you're still limited in the amount you can gift, but that limit is now raised to $5,000 from $500. And a big change is in the way the document can be executed by those with a physical disability that still have mental capacity to say that they would like somebody else to act on their behalf as power of attorney. That difference is going to be huge for those with ALS, for someone who's quadriplegic or any other person with a physical disability that makes it so that they cannot sign or initial the document on their own behalf, because the document requires that when you want to give these powers, the principal signs, dates, and initials in certain places in front of a notary. The new law says that somebody can sign the document on behalf of a physically disabled person who has mental capacity to sign, and they just sign their name and state that they're signing on behalf of another. That will require that the individual be in the same room as the person signing and have the capacity to state that this is what they want to do. There will be someone there signing on their behalf. There'll be a notary, and then there'll be an additional witness. And all those people will have to be in the same room and sign at the same time. This is going to be huge, and this is going to be very helpful to those with those physical disabilities. And so we're very excited about this change and the opportunity that it opens up for our clients that do have those disabilities. The document, like I said, used to have that statutory gifts rider, but we've now taken all of those powers that were to create the trust, to give gifts to your children, to your grandchildren, to charities. We've taken all of those provisions, and if we now want to give the agent that authority, we've put those provisions right into the modification section of the original document. So it no longer requires that separate rider. The rider, again, had to be signed at the same time as the power of attorney, so it was incredibly confusing for people to understand why there were two separate documents that had to be signed together and attached to each other, but they weren't actually the same document. And hopefully this new law will clear up some of that confusion. Again, we still need to put those gifting powers in, we just put them in the original document. You also have to initial where it says that you're giving specific gifting authorities beyond that $5,000 amount. The other changes to the statute are perhaps in what we call the construction section. So on the first portion of the document, it gives certain statutory powers. We often refer to them as the A through O powers. It includes real estate transactions, insurance transactions, retirement transactions. And when you've heard people say this is a short form power of attorney, what that means is that the document itself does not include a description or definition of all of those individual A through O powers. The definition of those powers is listed in the statute. We have made changes to some of those provisions in the statute to the definitions of those powers. So again, if you hear somebody talking about a short form, it's because it doesn't list out all of those separate definitions. The other really big change is going to be in how a bank or other institution, a title company, anyone that you're presenting the power of attorney to, you want them to honor it and honor the agent acting on behalf of the principal. You will hand over that document, and the institution that you're looking to accept it will need to reasonably review it and can only refuse to accept it if they're being unreasonable. Now, there are many people, maybe some people on this webinar today, who have tried to bring a power of attorney document to a bank or other institution and have been told it's too old, or that there's something wrong with the document and they will not accept it. We're trying to make it with this new law so that happens less. And we're trying to put a situation in place where these institutions are encouraged to accept what otherwise seems to be a valid document. So the agent can sign something attesting to the fact that this is a valid document, and to the best of their knowledge, it has not been revoked in any way. There can be an opinion letter of counsel, an attorney, if the bank wants or the institution wants, saying that the attorney believes this to be a valid document and witnessed the execution and has reviewed the document. Then, if the institution does not want to accept that document, they've got 10 days to either honor it or reject it. This is actually written into the new statute. We never had this before. We never had a process to be followed in order to accept or honor a power of attorney. And so hopefully, again, by having this process actually written into the statute, we're creating a situation where an institution is more likely to accept a document that isn't glaringly wrong or abuses aren't being made. If within that 10 days they reject the document, they have to do so in writing, and the person wanting that document to be accepted, say it's the agent under power of attorney or perhaps even the principal, can then respond. There's no time limit in which they have to respond as to why they think the bank is wrong about accepting the document. And then once they resubmit with further information, the bank or institution has 7 days to give a final acceptance or rejection of that document. If the person trying to get that document put on file then decides to bring a lawsuit saying that the institution is being unreasonable in not accepting the power of attorney document, and that the court agrees and that institution is found to have been unreasonably acting and unreasonably rejecting to take on the document, well, then damages can be assessed, including reasonable attorney's fees and costs. Again, the idea being that if an institution does not have any good reason to reasonably reject the document, then we want them to accept it so that these documents can continue to be used to assist people as they need further assistance from their agent down the line. Again, either in incapacity or maybe not. Maybe they're just unable to make it to the institution. Maybe it's difficult for them to write out the checks and they want somebody else to do it. These are all reasons why we would want an institution to reasonably accept this document. Just as with the old document, if I sign it as principal and I have it notarized and have 2 witnesses, one of which could be my notary, I can then hold on to it. I don't have to hand it over to my agent. So I can keep it in my possession. And my agent at some point before they want to act or before I want them to act can take the original document. They then have it signed and notarized. And then as a third step, that document has to be presented to whatever bank or institution we want to accept it. Once that process is completed, the agent's name can be added to the file as an authorized person, and the agent can go forward and act. Again, not instead of and taking away the powers of the principal, but duplicating the powers of the principal so that they can act as well. That was the case with the prior document, and that will be the case with the new document. Now, what's going to happen to your old document? As I said, if it was valid and validly drafted and executed at the time you signed it, well, then it will still be valid. And what we suggest is that you review your power of attorney document, or that you take this change in law as an opportunity to review your estate plan to make sure you don't need any changes to your plan or to your documents. If you are a person who had a power of attorney document that was signed prior to the last change in law, the 2010 change in law, then it's probably a good idea to get that document redone now and signed now under the new law that's going to come into play next week, because you don't want to be in a situation where the document is so old that the institution or wherever it is that you want to accept it is unfamiliar with the document and can't easily tell if it is a valid document or not. So if you have a very old document, you'll want to have it signed. Also, you may have a document that was signed a long time ago. 2010 was 11 years ago. So maybe 11 years ago, your thoughts about the type of help you might need might have been different. You might not have granted all of the powers to your agent under the power of attorney that you might do today as you're 11 years older, and potentially seeing that additional help might be needed. Your assets may be different now in both monetary value and also how you own assets. You may have owned a home that you've since sold and converted to cash or to investments. You may have had large retirement accounts then that you were drawing down that have now been converted into another type of asset. So 11 years later, a change in the law, you should really be checking in with your attorney to make sure that there aren't changes required to your plan that would make sense based on this change in law and other changes in the law. So whether or not you should sign a new power of attorney document will be based on the specific advice that we think that you should get from your attorney. The most important thing for people to know with this law is that you don't have to panic if you signed a document 3 months ago, a year ago, and now all of a sudden you need a new document. So it's not going to be necessary in all cases. And I don't want everybody to see that there's a new law and think that, well, this means that everything now that we have is invalid. Again, it's just a time to check in and make sure that your wishes are still being followed. If anybody wants to ask any questions, we have a Q&A on your screen. You can type them right into that Q&A, and I'd be happy to answer them. As people think about that and see if they have questions to ask, I want to go back and just talk about some other documents that we like to have in addition to the power of attorney. Your healthcare proxy and potentially a living will. The healthcare proxy is a document that says who will make medical decisions for you if you become incapacitated and are unable to make them for yourself. I like to talk about the healthcare proxy when I talk about the power of attorney because I like to point out the differences. So first of all, the power of attorney is financial matters, whereas the healthcare proxy is for medical matters. So the financial power of attorney, in other states, they actually call the healthcare proxy a healthcare or a medical power of attorney. We don't use that terminology here in New York. We call it a healthcare proxy. So that's one difference. They handle one's medical, the other's financial. The other difference is that the healthcare proxy requires that you be incapacitated for somebody else to act on your behalf. Now, that could be a short-term incapacity, like you're under anesthesia or you're in a medically induced coma, or it could be a long-term incapacity, such as a long-term vegetative state, or perhaps a lack of capacity due to dementia, Alzheimer's, or some other disease, a traumatic brain injury, for example. And so that's a big difference. That power of attorney document in almost all cases is not going to require you to be incapacitated, whereas that healthcare proxy will. And you need and should have both of those documents. And then a living will states whether or not you would want your agent under the healthcare proxy to make the decision to withhold or withdraw certain treatments because they believe you and they believe the doctors say that you are in an irreversible state with no hope of recovery. So that's the difference between the healthcare proxy, the living will, and the power of attorney. I think we have some questions, Liz, if you want to read them out.
We do. The first question, does the new law help when you just need a new debit card for an account you already have power of attorney for?
So if you have an existing power of attorney document and it's been presented to a bank and the bank has put that agent on the account as power of attorney, then that agent under power of attorney can receive the new debit card from the bank, but that's not a change from the old law. That's still the same as it always was, because that old power of attorney document or that prior signed power of attorney document is the power of attorney document that's on file with that institution.
Thank you, Britt. Next question. Can you assign one person primary and another secondary if primary predeceases you?
Yes, you can. You can actually name more than one power of attorney as primary, and you can always and should always name successor agents. For example, if you have a spouse and 2 children, you may name your spouse as primary and then your 2 children as successor agents. And then for your 2 children, you can choose whether or not they can act separately or if they have to act together. And that's right on the document that you can initial if you want them to be able to act separately. The default is that they will act together. You can actually in the document also put a tertiary or a third level of agents to act, and you can state when those new third agents come into play and when they start acting. Will it be when one of your 2 successors have passed away, or will they both have to pass away? And you can specify that right on the document.
Thank you, Britt. Next question. If you're incapacitated, how does the healthcare proxy request from the power of attorney agent to release monies for paying hospital bills?
The coordination between a power of attorney agent and the healthcare proxy agent is a very important relationship. So my first conversation with clients is, do you want the agent under your power of attorney to be the same person as your healthcare proxy? If they are the same person, then you don't have an issue with this. And the agent is making medical decisions and they're in control of the funds to support that. When you have 2 separate people or separate groups of people acting in these capacities, you need to first of all make sure that those individuals get along. I have seen in multiple cases where someone named maybe a spouse from a second marriage to act as healthcare agent, and then maybe a child to act as power of attorney. And if they disagree about the course of action for someone's care, unfortunately, the person holding the purse strings tends to win out in that argument, because in the end, no matter what the healthcare agent decides, there has to be the monetary ability to support that decision. And so hopefully they are able to work together and they're actually making those decisions together, so there's not a problem.
Thank you, Britt. Next question. Previously, a bank refused to qualify a power of attorney as valid due to the unsigned gift writer. Can I resubmit?
So if the gift writer was not signed at the same time as the original power of attorney document, then there will never be a gift writer for that power of attorney. So if the individual who was the principal on that original power of attorney wants to give gifting powers to their agent, then that person should sign a new power of attorney with the gifting authorities added in and submit that to the bank to accept. Because again, the old law, or the law that we're under for the next 5 days, was that when you signed the power of attorney document, you had to sign the statutory gift writer at the same time and have them attached.
Thank you, Britt. Next question. Are we still able to execute power of attorneys remotely, especially for a principal who is physically unable to sign for himself, herself, and requires a notary and a person signing on behalf of principal to be in the same room?
So currently, under the executive order, the emergency order that the governor signed back last March, allowing for remote notary and witnessing of documents, we are able still, under that emergency order only, to sign on a remote basis. So what that means is if my client is in their home and I am on Zoom or on FaceTime or something where I am live watching them and talking to them, not a taped video, I can witness the execution of the documents, and we can transmit them to each other electronically, and they can end up with a completed document if we follow the rules properly. However, that will expire at some point because that was an emergency order due to COVID. It's possible that New York State will come up with a remote notary, remote witnessing procedure that will be more long-term, but there is no current law that states that that can be done.
Thank you, Britt. Where can we find the new form?
So the new form is not something, and we never recommended that people get their power of attorney from the internet. The form allows for a lot of modifications by attorneys, allows or individuals, and it requires certain places where an attorney should be advising you as to the powers that you're giving away. And so the form is not something that you can just download and sign. Unlike the healthcare proxy form, which is online at the New York State Department of Health website. So the power of attorney form is one that you should really be seeking advice, just like an attorney should be advising you on executing, for example, a last will and testament or a living trust. So should be the same with a power of attorney document. I'll tell you that in our office, we've been working together, all of the attorneys, to come up with a power of attorney that we will be using in our office. And even within that document that we've created, there's a lot of choices that we will have to be discussing with our clients and then putting in the proper language based on the client's wishes, expectations, and personal situation.
Thank you, Britt. I don't see any additional questions at this point.
Okay, great. Well, thank you everyone for joining us. Again, the takeaway is you should be reviewing your power of attorney document and making sure that it still is going to follow your wishes and that it was valid when it was signed and that you don't need to execute a further document. Good luck with the new power of attorney law, and we hope to see you on our webinars and in person real soon. Have a nice day.
Perfect. Thank you, everyone. Have a wonderful day.